Hello, check. Check.
And additional public prosecutor. And there is private counsel
Yes, Mallam. We have already informed
Okay.
our phone.
and for the respond number 2, comma, list the appeal. The appeal
Okay.
stands adjourned for a week. The office to list the case appeal after a week. On a date to be fixed by the office.
Daily list for admission item number 1.
This criminal appeal from jail is directed against a judgment and order dated 30/10/2023 passed by the Court of Law and Special Judge within bracket POCSO Tinsukia in
Highly obliged.
Item number 2.
Legal Aid Council,
Yes.
advocate, joint legal, okay. Learned Legal Aid Council appointed to represent the accused appellant. He is found absent to the on-call post of MS A. Begum. Learned additional public prosecutor for the respondent number 1, State of Assam. Is in attendance post of this criminal appeal under section 374(2), Code of Criminal Procedure 1973 is directed against a judgment and order dated 15/12/2020 passed by the learned Sessions Judge Jorhat in Sessions case number 151 within bracket J-J of 2017, post up by the judgment and order dated 15/12/2020, the learned. The accused appellant has been convicted for the offense. How many? Page on the column. কিজন আছে? তিনজন আছে। সন্দীপ পাঠান, তো সন্দীপ পাঠানকে দিলেন কি? The accused appellant has been convicted for the offense of murder under section 302 IPC, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for another 1 month. So the appeal is admitted for hearing. The case records of Sessions case number 151 J-J of 2017 be called for issue notice returnable in 4 weeks as MS Begum, respondent of 1. Extra copy of memo appeal. The accused appellant shall take steps for service of notice upon the response number 2 by registered post with AD within 3 working days from today.
কিশোর ডিসটেন্স করে দিন পার্টি বানাইতে ভিডিও তো দোকান গেলে পার্টি বানাইতে দিয়ে কিছুই করতে
Item three.
May please, your lordship.
Heard Mr. A.R. Som. Learned counsel for the accused appellants. NMS A. Begum. Learned additional public prosecutor for the respond number 1, state of Assam, post of this criminal appeal under section 374(2) Code of Criminal Procedure 1973 is directed against the judgment and order dated 16/5/2024 passed by the learned additional sessions judge Shiv Sagar in sessions case number 84 within bracket as there's a of 2018 post up by the judgment and order dated 16/5/2024 two accused appellants.
Two accused appellants.
The two accused appellants have been convicted. No 34 have been convicted
No 34.
under section 304B Indian Penal Code, and they have been sentenced to undergo rigorous imprisonment for 10 years. No fine. No fine.
Lordship, fine is not mentioned, lordship.
Okay. Post up. The appeal is admitted for hearing. The case records of so and so case number be called for, issue notice returnable in 4 weeks as MS Begum has appeared accepted. Notice on behalf of the respondent number 1, state of Assam. Issuance of formal notice can dispense with. However, the accused appellants shall take steps for service of notice upon the respondent number 2 by registered post with AD within 3 working days.
Oblige, your lordship.
Item number 4.
May please, your lordship. Appeal against the impugned judgment and order passed by the learned additional session judge from Special Judge Poksho Tinsukia.
You are one of the 3.
Yes, lordship.
Heard Mr.
D. Medhi, lordship.
D. Medhi.
Yes, lordship.
It's an NCB matter, Lordship. Also, I'm appearing for Mr. Kyle, Lordship. He is in some of the courts.
D. Medhi, learned counsel for the accused appellant, and MS S. Bora, learned counsel representing Mr. S. C. Kyle, learned public prosecutor for the respondent Narcotics Control Bureau. Full stop. The instant criminal appeal under section 374(2) Code of Criminal Procedure 1973 is directed against a judgment
$23,000.
33 2020, page 18, lordship.
an order dated 30/03/2024 passed by the Court of Learned Additional Sessions Judge number 1, Kamrup, within bracket M, Guwahati, within bracket, quote unquote, the special court, for short. In NDPS case number 110 of 2021. First. By the judgment and order dated 33/2024, the Learned Special Court has convicted 3 accused persons, including the accused appellant, for the offense under section 20, within bracket small b, within bracket small Roman 2, within bracket small capital C, narcotics. NDPS. NDPS Act 1985, read with section 29, NDPS Act. Full stop. The accused appellant has been convicted, sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 1 lakh. In default of payment of fine, to undergo simple imprisonment for further 3 months. The appeal is admitted for hearing. The case records of NDPS case number 110 of 2021 be called for. Issue notice returnable in ASICAL ASICAL Sage 1 alage. As Mr. Cal learned, public prosecutor NCB has appeared and accepted notice on behalf of the respondent NCB. Issuance of formal notice dispensed it, however, extra copy. Returnable 4 weeks this, no? At this stage,
Yes, IA 6
let the LCR come.
Obliged.
In the meantime, we'll file our objection.
Okay, then we'll issue notice that.
Obliged.
Heard Mr. D. Medhi, learned counsel for the applicant appellant, and Mr. S.C. Kyle, learned public prosecutor, Narcotics Control Bureau for the opposite party. Full stop. Opposite party NCB. Full stop. The instant application under section 389(1) Code of Criminal Procedure 1973 is for suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Full stop. The applicant as the appellant has preferred the accompanying appeal, criminal appeal number so and so against the judgment and order. The opposite party is to file objection to the instant application on or before the returnable date. Issue notice for returnable.
That's all right.
All orders, item number 6.
Yes, Mr. Das, SR.
Lordship, I have not received any report, Lordship.
Huh?
I have not received any report, Lordship.
Wait, it is ready already. I heard. Ms. B. Sharma. B. Sharma, amicus security for the accused appellant, and Mr. A. Das, K. Das, learned additional public prosecutor for the respondent state. So Mr. Das, learned additional public prosecutor, has sought for 2 weeks' time to obtain a report as eager service of notice upon the informant by the officer in charge, Urang Police Station, Urang Police Station, Urang, it Dibrugarh noy, Bolpur jane. Urang Khoang Police Station, Dibrugarh. Place the case accordingly after 2 weeks.
Item number 7.
In 7 also, I have not received any report, Lordship. I have asked telephonically, and he has stated that he has not received notice, Lordship. So I have to look into it that way.
Paper book. Notice has been issued. To the officer in charge. Reduced. So, public prosecutor on a.
Driving is such a good.
Office note also. Me too, first office note too. The date to hold. 8/23/03/2020. Earlier was by register post perhaps or something like that. Not through the office of the public prosecutor. Heard Mr. Andreka learned amicus curiae for the accused appellant and Mr. K.K. Das learned additional public prosecutor for the respondent number 1, State of Assam. Post of. As the offense involves
Lordship, service report has come, but it has been, other side has, informed my learned friend to keep the matter for the time being, but I have received a report, madam.
other side means appellant.
Appellant side.
What is this? Already we have observed, I think. Notice has been duly affected, already observed. We need to appoint a legal aid counsel.
Lordship, please do it.
Also there. Legal aid counsel, legal will come back. Official business of the forward. Legal counselor will transfer. the case नहीं
My lord, I'm sorry, my lord, I was in court. My lord, here paper book is not prepared.
Heard Mr. B. Borua, learned counsel for the appellant MS and MS B. Bhuyan, learned senior counsel and additional public prosecutor assisted by MS M. Chakraborty, learned counsel for the respondent number 1, State of Assam. Full stop. In the previous order dated 21/6/2024, it was observed that the notice had been duly effective. Counsel for the accused appellant is found absent to the uncalled post of MSB Bhuyan, learned additional senior counsel and additional public prosecutor appearing for the respondent number 1, State of Assam has sought for listing of the appeal on Friday.
Fine.
In order to obtain a report as regards obtain a report and place a report as regards service of notice upon the respondent number 2 das informant from the officer in charge, Lanka Police Station, District Gujarat. List the case accordingly on so and so.
Item number 10.
My lord, may I please lodge? My lord, this matter, already my lord, pleadings are completed and my lord, scan copy is also available in the record. So this matter will kindly fix for hearing, my lord.
Okay, not this week, next week,
My lord, if
after week,
possible, my lord, 30, my lord.
after week, any day.
My lord, if
This is not by Honorable Justice Fukan, right?
yes, my lord.
So he'll be available this week. So perhaps next week he may not be available.
My lord.
Next week,
My lord, if
we'll post it for hearing. If it is not conducive to you in the next week, then it will be posted accordingly. I heard Mr.
my lord,
K.
Singha, my lord.
Sinha, learned counsel for the appellant, and Mr. D. Bharadwaj, learned counsel for the respondent number respondent NI. Full stop. As the scan copies of the case records have been received, list the appeal for hearing after a week on a date to be fixed by the office.
Item number 11.
May I please the lord?
কি করবো এটা? To condonation.
This I for condemnation of delay.
Offense IPC 302
302.
84 days. Yes, MS Bora
Yes.
heard Mr. A. Rahman,
My lord.
learned counsel for the appellant, and MS S.H. Bora, learned additional public prosecutor for the opposite party number 1, State of Assam. Full stop. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 84 days in filing the accompanying criminal appeal under Section 374(2), Code of Criminal Procedures 1973. Full stop. The accompanying criminal appeal is preferred against the judgment and order dated 59/2023, passed by the Court of Learned Additional Sessions Judge Command Dhubri in Sessions Case number 160 of 2018, full stop. By the judgment and order dated 59/2023, the accused, he is the only convicted person? Or
There is
How many?
more?
request is to what I am for
Huh?
one,
Okay. You are Uttam Biswas,
my lord.
the accused appellant, has been convicted for the offenses. Page 53
Page 53.
আছে, হ্যাঁ, appeal to. Only under Section 302?
No, there
Or
are
more?
some other
And
sections.
324,
302 and?
324, 447.
Okay. For the offenses under sections 447 stroke 324 stroke 302 of the Indian Penal Code. Full stop. For the offense under section 302, IPC, the appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, with default stipulation. Full stop. The appellant has been sentenced for the offense under section 324 IPC to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 1,000, with default stipulation. Full stop. For the offense under section 447, IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 1 month. Full stop. The learned trial court has ordered that all the sentences are to run concurrently. Full stop. Para. The The period of delay of 84 days very cryptic,
My-
very cryptic,
Surprise.
cryptic of the highest order. The applicant has explained the reasons for delay of 84 days in paragraph 3 of the instant application. Full stop. Para. MS Bora Learned Additional Public Prosecutor appearing for the state has submitted that though the period delay of 84 days has not been explained properly, comma, the state has no objection if the court condones the period of delay on the premise that the the appeal is required to be heard on merits, accompanying appeal. Full stop. We have found course in the submission of the learned additional public prosecutor. Full stop. Though the period of delay of 84 days has not been explained in a manner required, comma, we are of the view that instead of we have the considered view that for the purpose of to subserve the justice command accompanying appeal is required to be heard on merits as the appellant has been sentenced to undergo life imprisonment. Full stop. We are also of the considered view that at this stage, comma, the opposite party number 2, as informant, will not be prejudiced in any manner as the accompanying appeal will be heard on merits. Full stop. In view of the above observation, comma, the period of 84 days, which is stated to have occurred in preferring the accompanying appeal, stands condoned. Consequently, comma, the instant application under Section 5 of the Limitation Act 1963 is allowed. Full stop. Office to register the accompanying appeal and thereafter to list the same for admission in due course.
Much obliged.
For hearing, item numbers 12 and 13.
Yes,
May please, your lordship.
two appeals.
Yes. I am in item number, your lordship, 12. I am for Nippon Fukon.
Kolita, Mr. Kolita is available. Okay.
Yes. Your lordship, this is an appeal against an conviction of the accused.
Bora, you are ready?
We have to receive the.
No paper book or paper book?
No, we have to do in the office, lordship, because of due to vacation, we couldn't go through it, lordship.
Not received,
I have received today on itself.
not ready, or ready,
It's not ready, lordship.
not ready.
Some other day it is.
Some other day. কালি আছে নেকি? কালি কিমান আছে? কালি কিমান আছে? হ্যাঁ? And in criminal appeal J, item number 12. And Mr. A. Kolita, learned amicus curiae for the appellant in 13 are present, full stop. On the request of Ms. S.H. Bora, learned additional public prosecutor for the respondent state, comma, list the appeals after a week on a date to be expired by the office.
Highly obliged.
Obliged.
I think.
Once again,
Huh.
because
But I
my
brought this regular
brother,
case, lordship. if
my
lordship
brother did not heard it.
was- That's,
It was brother of Justice Phukan.
yes.
I think it will be better. It will be,
After 2 days, the bench would.
yes, yes. So we'll put it
No,
on Thursday.
Fine.
Yes.
I'll give, yes. Aluwalia case, Dada,
এটা আমি কোনটার মধ্যে এটা প্রসিকিউট করবে
in this case to,
কত কথা লোকেরা ছিল আর বিজেপি রিভিউ করে
this is from UK lordship, but then.
UK.
Lordship, then, but then lordship provocation, our law has also evolved from that only lordship. And on provocation, two things were argued in this case. One is about provocation and second was diminished responsibility.
Hmm.
The court held that provocation was not there because of Duffy's case. Duffy's judgment lordship, I could not download it, but in the meantime on Thursday, I'll try to bring it. Duffy's, the proposition was that the provocation should be, and provocation and the action connected to the provocation should be sudden and immediately. There cannot be a thinking period. So in my case, I want to use that because immediately, and lordship 161 statement that day, both of us we read, and that is disgusting what the, I mean, what he's told the, but that was correct.
Just let me read the FIR and it will come.
No, lordship, on Thursday also, no.
No, just
Yes.
Here accused killed his mother, my lord. Your lordship also read the 161 statement.
just
Yes, ma'am.
15 days is too long a
Yes.
period. Okay. Son
Son killed his
Son-
father.
from her first marriage.
And
Then the disease remarried for a second time.
lordship.
Thursday?
But there is no cross-examination to that effect. So lordship on the other last occasion, after seeing the 161 statement, there was no cross-examination.
Okay.
Lordship, I have also brought two judgments. Should I?
Let us
refer
see.
it?
Let us see.
Nanavati.
Nanavati.
Nanavati is totally different lordship because Nanavati,
Plan.
he planned, he went back to his office, brought out the gun, he killed, and he doesn't kill his wife, he kills only that person. So,
Anil Kumar.
and ultimately he was, the governor, gave him a pardon.
Which
Not-
paragraph?
Anavati, madam. Para 85, 86. your lordship.
85.
I will do 85 and 86.
85.
My lord.
Okay, let us read for 85.
85. The Indian
86.
law relevant to the present inquiry may be stated thus: the case of grave and sudden provocation is whether a reasonable man belonging to the same class of society as the accused placed in a situation in which the accuser's place would be so provoked as to lose his self-control. In India, words and gestures may also, under certain circumstances, cause grave and sudden provocation to an accused so as to bring his act within the first exception of Section 300 of the Indian Penal Code. The mental background created by the previous act of the victim may be taken into consideration in ascertaining whether its subsequent act caused grave and sudden provocation for committing the offense. The fatal blow should be clearly traced to the influence of passion arising from the provocation, not after the passion had cooled down by lapse of time or otherwise giving room and scope for premeditation and calculation. Bearing these principles in mind, let us look at the facts of this case. When Sylvia confessed to her husband that she had illicit intimacy with Ahuja, the latter was not present. We'll assume that he had momentarily lost his self-control. But if his version is true for the purpose of his argument, we shall accept that what he has said is true. It shows that he was only thinking of the future of his wife and children and also asking for an explanation from Ahuja for his conduct. This attitude of the accused clearly indicates that he had not only regained his self-control, but on the other hand was planning for the future. Then he drove his wife and children to a cinema, left them there, went to his ship, took a revolver on a false pretext, loaded it with 6 rounds, did some official business there, and drove his car to the office of Ahuja, and then to his flat, went straight to the bedroom of Ahuja and shot him dead. Between 1:30 p.m. when he left his house and 4:20 p.m. when the murder took place, 3 hours had elapsed, and therefore there was sufficient time for him to regain his self-control, even if he had not regained it earlier. On the other hand, his conduct clearly shows that the murder was a deliberate and calculated one. Even if any conversation took place between the accused and the deceased in the manner prescribed by the accused, true, though we do not believe that it does not affect the question. But the accused entered the bedroom of the deceased to shoot him. The mere fact that before the shooting, the accused abused the deceased and the abuse provoked an equally abusive reply would not conceivably be a provocation for a murder. We therefore hold that the facts of the case do not attract the provision of Section 300 of the IPC.
Rustom.
Rustom is the movie.
My lord.
Rustom.
In our case, my lord, the accused person went to the victim went to the neighbor and informed, and she came back. Then thereafter, the offense had taken place. So there was cooling period.
So
probably
enough
that-
time to regain
Yes,
self-control.
yes. So another judgment under Reliance Air 2023 5512.
What has been abolished after Nanavati?
Oh,
What has been abolished?
section. Lordship, I'm not aware of it. my
Not
lord.
aware. The jury system.
Oh, jury system, my lord, yes.
Yes. Any other judgment?
Air 2023, Supreme Court 5512. Para 2021,
Para 20,
2021, 23 and 24.
20, 21 and
23 and
23,
and 24.
20. Let us have a reading. We'll read again.
Lordship, para 20,
20. Yes.
para 19. In support of his above, our learned counsel for the appellant relied upon Kaluram versus State of Rajasthan, which is case of similar kind in connection with illicit by burning. However, it would be relevant and material to refer exception for Section 300, which defines murder. Before extending the benefit of the above decision to the appellant, that said exception reads as under Exception 4. Culpable homicide is not murder if it is committed without premeditation, in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage
This is
of.
exception 4.
Yes, my lord, we are on exception 1.
One.
Maybe. Lordship, that para 20. It is on the strength of the above exception that from side of the appellant, it has been argued that the appellant is not guilty of murder as he had no premeditated mind and that the action of the appellant arose out of a sudden fight. In the first place, the fight was not sudden. The appellant and the deceased wife had a past history of quarrel. Lordship will kindly note this part. And that they had been quarreling on the fateful day also since before the actual incident. During their quarrel, a neighbor, Sahajahan, that is PW1, had visited their house and the deceased wife had shown some injuries received by her during the assault. However, realizing the quarrel between the two, he left saying that he would come later on. It was thereafter that the incident of pouring kerosene and burning took place. So, there was sufficient time in between the two acts and it cannot be said that there was a sudden quarrel and provocation leading to burning. The appellant saw the deceased wife drenched in kerosene and was conscious that if lighted, she would be burned to death even then ignited her to fire. This showed premeditated mind to kill her. More particularly, the appellant cannot take advantage of the fourth exception only on the pretext that it was not on account of premeditated mind or out of a sudden fight, or that his intentions were not bad as he tried his best to douse the fire and to save the life of the deceased wife for the reason that the benefit of the above exception would have been available to him had he not taken undue advantage of the situation. The exception clearly in unequivocal terms states that it will be applicable where culpable homicide is committed not only without premeditated mind in a sudden fight or quarrel, but also without the offender taking undue advantage of the situation. In the present case, the appellant, upon seeing the deceased drenched with kerosene, clearly took advantage of the situation and lighted a matchstick and drew it upon her so that she can be burned. The appellant, having taken undue advantage of the situation, cannot be extended the benefit of exception 4 to section 300 IPC, so as to bring the case within the ambit of part 2 of 304. In view of the above legal position, the ruling cited by so Kaluram would not benefit the appellant. The first information report and dying declaration on record clearly contained the statement of the deceased that when she had poured kerosene upon herself to deter the appellant from fighting and assaulting, he lighted a matchstick and with the intention to kill her, threw it upon her by saying, "You die." The aforesaid evidence cleanses the issue and establishes beyond doubt that the appellant is guilty of the offense of culpable homicide amounting to murder and is not entitled to benefit of exception 4 of section 300 IPC. Accordingly, we are of the opinion that the courts below are not committed an error, fact or law in convicting the sentencing him to maximum punishment.
From Ahluwalia, which part?
Lordship, Ahluwalia, before that, there is a discussion on that, sir. And notes.
Third page
Hmm.
or fourth?
Fourth page and notes and
And notes.
actually held Lordship last page
Held.
held. The judge's direction on provocation was correct. The Duffy direction was good law and the judge had directed the jury on the issue of abuse suffered by the appellant and thus the jury would have considered the effect of this in reaching their verdict. The appeal on the ground of provocation was therefore unsuccessful. And that's what I'm going to use that Lordship, the Duffy in our case. The other part was, however, the appeal was allowed on the ground of diminished responsibility. So the case was sent back to the trial court, Lordship, so that the diminished responsibility can, because if she's suffering from any mental. But I am on that provocation part, like the first part, which was rejected in this case. I'll try to bring that Duffy judgment.
Okay. R.D. Majumdar, learned amicus curiae for the appellant. And M.S. B. Mia, learned additional senior counsel and additional public prosecutor for the respondent state are present. So as sought for by the learned counsel for the parties, lays the case appeal on Thursday.
Lordship,
87.
Highly obliged.
if I find out something.
For motion item number 1. Lordship, The petitioner was appointed as a grade 3 stenographer, Lordship,
Hmm.
in the district and session judge Nagaon, establishment of district and session. He joined on 22/9/2016, Lordship. And her pay was fixed initially in the pay scale of 5,200 to 20,200 plus grade pay of 2,900. That was in the earlier Lordship, six pay under 6 pay commission. Subsequently, it was revised and the grade pay was enhanced to 7,400, Lordship. But the pay band, Lordship, there was a discrepancy with regard to that. Subsequently, there was a clarification made with regard to that Lordship will find at page 48. This was by this honorable court, Lordship. And at the bottom portion, it was fixed at 27,000.
So, yeah, when did you join?
Lordship, I joined on 22/9/2016, Lordship.
MS Sharma, you appear for High Court. Three, 4, and 6.
Lordship, there is an order whereby Lordship, a recovery was sought to be made, Lordship, and recovery, Lordship, was recovery of an amount of rupees 1,68,644. That Lordship will find at page 68, Lordship. That recovery is still continuing, Lordship, and I am praying that further recovery may not be made, Lordship. Because
It was more than 2 years.
yes, Lordship, but then she preferred presentation before the authorities, and that was subsequently rejected, Lordship. And she was required, threatened, Lordship,
How much?
at page 70, Lordship. That was rejected and she was told not to approach, Lordship. So she probably, Lordship, stayed back, Lordship. And subsequently, Lordship, she approached.
Which page? Recovery?
Lordship, recovery page 68.
68.
Recovery to what is it? Lordship, I am relying upon two decisions of the Honorable Apex Court in order to submit that, Lordship, that further recovery may not be made, Lordship. Citation to hold 1975 3 SCC 1. 1994 6 SCC 154.
Why you have come so late regarding recovery?
Lordship, as I told Lordship, it was the Lordship
Application
Chief
rejected.
Administrative Officer in that establishment, Lordship, which Lordship
Okay, we'll pass the order on interim on the returnable date. We'll issue notice. Heard. Mr. MP Sharma. Learned counsel for the petitioner and MS S. Sharma, learned standing counsel Guwahati High Court for the respondent number 3, 4, and 6. The learned government advocate Assam for the respondent number 1 and the learned standing counsel Finance Department for the respondent number 2 and 5 are found absent today on call, though their names are reflected in the cause list. Full stop. The case of the petitioner comma, in brief, comma, is that when provide an advertisement dated 12/6/2015 within bracket annexer 1. Applications were invited for filling up 191 number of vacancies in stenographers grade Roman 3 for the subordinate judiciary of Assam in the scale of pay of rupees 5,200 rupees 20,200 with grade pay within bracket ZP of rupees 2,900 within bracket PB2 plus other allowances were invited, comma, the petitioner submitted her application in response to the said advertisement dated 12/6/2015. Full stop.
Results were published on 30th July.
After completion of the selection process, which included stenography test, comma, the respondent number 2 published a notification dated 30/7/2016, Annexer 3,
My name is at serial number 129, page 36.
wherein a list of 138 candidates was published list of 138 provisionally selected candidates was published. Full stop. In the said list of candidates, comma, the name of the petitioner figured at serial number 129. Full stop.
Page 39 is the amendment.
Originally, comma, the petitioner was sought to be posted as stenographer grade 3 in the office of the Chief Judicial Magistrate Nalbari. Full stop. However, comma, by a notification dated 4/8/2016 within bracket annexer 4, comma, the petitioner was allotted in the office of the District and Session Judge Nagaon. So accordingly, comma, the District and Sessions Judge Nagaon within brackets respondent number 4 issued an appointment order dated 21/9/2016 within bracket Annexer 5, whereby the petitioner was appointed as stenographer grade 3 in his establishment against a newly created post of stenographer grade 3 in the pay scale of rupees 5,200 to rupees 20,200 plus rate pay of rupees 2,900 and other allowances as admissible under the rules. Full stop. On receipt of the appointment order dated 21/9/2016, the petitioner joined on 22/9/2016 by submitting a joining letter, Annexer 6, full stop, para. It is the case of the petitioner that she continued to receive her pay and allowances in the scale of pay of rupees 5,200 20,200 plus GP 2,900 during the period from 22/9/2016 till April 2018. Full stop. But from the month of May, the receivable amount was reduced from 29,475 to rupees 23,591 without any prior notice. Full stop. As similar situation had occurred in respect of similarly appointed stenographer grade 3, a representation was submitted by some similarly appointed stenographer grade 3 raising a grievance as regards reduction of the salary amount. Full stop. It is the petition has canvassed that by a communication dated 16/7/2019, the respondent number 2 had clarified that
No, it's not respondent number 2, Lordship. It's
Joint Register of Finance,
of Guwahati High Court.
definitely he will be under Registrar General, page 48.
The respondent number 2 is the
Oh,
deputy
three.
3, Lordship.
Three. That to the following effect. To the following effect particular is 48 or ঢাক মারার পর ঢাক মারা, হ্যাঁ ঠিক আছে।
The table which was referred to in page 48 is in the next page, Lordship, page 49. The serial number 10 is the one, Lordship.
Seen, noticed. Thereafter, in terms of the communication dated 16/7/2019, comma, the respondent number 4. While order dated 21/8/2019. Annexer 15. Prefixed. The pay of the petitioner at basic pay of rupees 20,590 with grade pay of rupees 7,400 WEF 2209/2016. Full stop. As the pay was not refixed, pay of the petitioner was not refixed. Disbursed.
It was not disbursed.
Not in terms of the order dated 21/8/2019, Annexer 15,
Lordship.
the respondent number 4 took up the matter with the respondent number 2 while it's later dated 19/8/2020, Annexer 18, right?
Lordship. It was not the petitioner, but the district and session judge Nagaon, Lordship.
Huh?
Through him, Lordship, Lordship, see.
Matter was taken up by the respondent number 4 with the respondent number 2 by the later dated, by its later dated 19/8/2020,
Lordship.
Annexer 18. Full stop. The petitioner also represented about the same, about the matter of refixation with the with the respondents by various representations. Full stop. In response to the letter dated 19/8/2020 within bracket Annexer 18, comma, The respondent number 2 provided a clarification by its communication dated 11/4/2022 within bracket annexer 22. Stating inter alia to the effect that the stenographers grade 3 who were recruited after the date of effect of Assam services within bracket revision of pay bracket close rules 2017, comma that is comma 1/4/2016, comma was to be fixed in the payment of rupees 14,000 with grade pay of rupees 7,400, comma that is comma rupees 21,400. Full stop.
Which page 67. One of the similarly situated person, Lordship, that Azizul Haq Chaudhary, again sought information under RTI Act. It was stated by the Finance Department that the matter is under
When a
examination.
similarly situated person made a representation before the respondent number 2, comma, the respondent number 2 filed its communication dated 9/9/2022, annexer 23, had mentioned that the proposal was under examination of the department. Full stop. But on the basis of a royal statement showing, quote, to be drawn amount and already drawn amount, unquote, comma, the respondent number 4 observed that an amount of rupees 1,68,644 have been overdrawn by the petitioner since her joining, and the said amount was to be recovered from the pay bills of the petitioner in equal monthly installment of rupees 5,000 from the pay bills of the petitioner on and from September 2022 onwards. Full stop. When a representation again by a communication dated 16/9/2022, annexer 24, comma, addressed to the respondent number 5. Full stop. When a representation was submitted by the petitioner on 23/9/2022, comma, the said representation came to be rejected by a letter dated 28/9/2022 within bracket annexer 25 of the respondent number 6, full stop, para, in the above backdrop, comma, the petitioner has contended that the petitioner is entitled to receive the pay and allowances in terms of the scale of pay of rupees 5,200, that's rupees 20,200, with grade pay of rupees 29,100 in pay band 2, comma, as advertised in the advertisement dated 12/6/2015. And there cannot be any deduction from the pay and allowances of the petitioner as directed provide the letter dated 16/9/2022. Post of. It is the contention of the petitioner that the pay and allowances, the petitioner is entitled to receive the pay and allowances in terms of the clarification given
Page 40.
right the communication dated 16/7/2019 within bracket and extra 12. This is your case?
Yes, doctor.
Post of. Issue notice returnable on
5/8, 5th August.
5/8. Notice is also issued on the interim pair. Post of. Paragraph Likhok. Mr. Sharma, learned counsel for the petitioner, has submitted that recovery is being made at rupees 5,000 per month since September 2022 from the pay and allowances of the petitioner. Post of. As such, recovery is not as per the revision of pay rules 2017 and unauthorized, comma, he has paid for containing that such recovery so and so. He has prayed for an interim order. So, making issue notice so and so. As MS Sharma, Learned Standing Counsel GHC, has appeared and accepted notice on behalf of the respondent number 3, 4, and 6. For no formal notice. However, the learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition along with an extra to MS Sharma within 3 working days from today. Post of. The learned counsel for the petitioner shall also serve extra copies of the writ petition to the learned senior government advocate Assam for the respondent number 1 and to the learned standing counsel finance department for the respondent number 2 and the respondent number 5
2 and 5.
within 3 working days from today. Post of. The prayer for interim relief will be considered on the returnable date, that is 5/8/2020.
No, like,
We have to put them on notice, otherwise 2 years you have been
that is their lordship.
sitting over the matter. You have lost weight, MS Sharma?